Edit S is waiting for you in the next room. The Real Matrix, Stefan Molyneux, YouTube, where franchises may lawfully be enforced. The important thing to remember about franchises is that Congress is forbidden from creating franchises within states of the Union. Why? Because 1. The Declaration of Independence, which is organic law, says our constitutional rights are unalienable. It was published as an organic law in the very first enactment of Congress in the first volume of the Statutes at Large. 2. An unalienable right is one that you aren't allowed by law to consent to give away in relation to a real de jure government. Such a right cannot lawfully be sold, bargained away, or transferred through any commercial process, including a franchise. Hence, even if we consent, the forfeiture of such rights is unconstitutional, unauthorized, and in violation of the fiduciary duty to the public officer we surrendered them to. Unalienable, inalienable, incapable of being aliened, that is, sold and transferred. Black's Laws Dictionary, 4th edition. 3. The only place you can lawfully give up constitutional rights is where they physically do not exist, which is either outside the country or among those physically present on Fed territory not part of any state of the Union. Indeed, the practical interpretation put by Congress upon the Constitution has long been continued and uniform to the effect that the Constitution is applicable to territories acquired by purchase or conquest only when and so far as Congress shall so direct, notwithstanding its duty to guarantee to every state in this Union a republican form of government. Article 4, by which we understand, according to the definition of Webster, a government in which the supreme power resides in the whole body of the people and is exercised by representatives elected by them. Congress did not hesitate in the original organization of the territories of Louisiana, Florida, and the Northwest Territory and its subdivisions of Ohio, Indiana, the territories of Louisiana, Michigan, Illinois, and Wisconsin, and still more recently in the case of Alaska, to establish a form of government bearing a much greater analogy to a British crown colony than a republican state of America, and to vest the legislative power either in a governor and council or a governor and judges to be appointed by the president. It was not until they had attained a certain population that power was given them to organize a legislature by vote of the people. In all these cases, as well as in territories subsequently organized west of the Mississippi, Congress thought it necessary either to extend the Constitution and laws of the United States over them, or to declare that the inhabitants should be entitled to enjoy the right of trial by jury of bail and of the privilege of the writ of habeas corpus, as well as other privileges of the Bill of Rights. All de jure governments are created exclusively to protect private rights. The way you protect them is to leave them alone and not burden their exercise in any way. A lawful de jure government cannot and does not protect your rights by making a business out of destroying, regulating, and taxing their exercise, implementing the business as a franchise, and hiding the nature of what they are doing as a franchise and an excise. This would cause and has caused the money changers to take over the charitable public trust and a civic temple and make it into a whorehouse and a violation of the constitutional trust indenture. This kind of money changing, in fact, is the very reason that Jesus flipped the tables over in the temple out of anger, turning the bribe of Christ and God's minister for justice into a whore. The nuns are now pimped out and the church is open for business for all the statutory taxpayer Johns who walk in. The above explains why. 1. The geographical definition within every franchise we have seen, including the income tax, the Social Security, etc., limit themselves to Fed territory exclusively and include no part of any state of the Union. See 26 U.S. Code 7701, 42 U.S. Code 1301, and 4 U.S. Code 1110. 2. The unconstitutional conditions doctrine of the U.S. Supreme Court limits what you can consent to in the context of franchises. 3. The U.S. Supreme Court held the following about licenses enforced in areas protected by the Constitution, keeping in mind that licensing implements franchises. The acceptance of a license in whatever form will not impose upon the licensee an obligation to respect or to comply with any provisions of the statute that are repugnant to the Constitution of the United States. How franchises are stealthily introduced and propagated by a corrupted government within the jurisdiction outside their territory. The State of the Union are legislatively but not constitutionally foreign and alien and sovereign in respect to the national government. Maintaining that separation of legislative powers, in fact, is one of the main purposes of the United States Constitution. We start with the first principles. The Constitution creates a Fed government of enumerated powers. See U.S. Constitution Article 1:8, as James Madison wrote. The powers delegated by the proposed Constitution to the Fed government are few and defined. Those which are to remain in the state government are numerous and indefinite. The Federalist Number 45, page 292-293. This constitutionally mandated division of authority was adopted by the framers to ensure protection of our fundamental liberties. Internal quotation marks omitted. Just as separation and independence of the coordinate branches of the Fed government serves to prevent the accumulation of excessive power in any one branch, a healthy balance of power between the states and the Fed will reduce the risk of tyranny and abuse from either front. That shit was loud as fuck. In order to break down this separation of powers and enact law that regulates the conduct of non-resident and alien parties domiciled in a legislatively foreign state, such as the State of the Union, the national government has to use contracts and franchises to unlawfully reach outside of Fed territory. It is a maxim of law that debt and contract know no place, meaning that they can be enforced anywhere. Debt and contract, franchise agreement in this case, are of no particular place. Locus contractus recat actum. The place of the contract franchise agreement in this case governs the act. Bauer's maxims of law. Those who are domiciled in the State of the Union in order to acquire a commercial existence, identity, or right in a legislatively but not necessarily constitutional foreign jurisdiction such as the Fed zone are mandatorily required to become privileged. Oh yeah. Here is an explanation of this phenomenon by the U.S. Supreme Court. They are talking about constitutional. Note also that legislatively foreign and alien inhabitants who are foreign nationals not within any state of the Union must be treated as possessing an implied license to do business in a foreign jurisdiction, which is in this case the national government, and therefore become privileged resident aliens. It is also a violation of the Constitution for the national government to treat those born in or domiciled within constitutional states of the Union like shit. The same as a foreign nationals because it deprives them of the privileges and immunities of constitutional citizens of the United States and thereby alienates their constitutional rights. Damn. Okay. The treasons for not allowing to other aliens exempt from the jurisdiction of the country in which they are found were stated as follows. When private individuals of one nation, states of the Union, are nations, under the law of nations, spread themselves through another as business or caprice may direct mingling indiscriminately with the inhabitants of that other, or when merchants' vessels enter for the purpose of trade, it would be obviously inconvenient and dangerous to society and would subject the laws to congenial infraction and the government to degradation. If such individuals or merchants did not owe temporary and local allegiance and were not amenable to the jurisdiction of the country, nor can the foreign sovereign have any motive for wishing such exemption. His subjects thus passing into foreign countries are not employed by him, nor are they engaged in national pursuits. Consequently, there are powerful motives for not exempting persons of this description from the jurisdiction of the country in which they are found, and no one motive for requiring it. The implied license, therefore, under which they enter, can never be construed to grant such exemption. In short, the judgment in the case of the exchange declared as incontrovertible principles that the jurisdiction of every nation within its own territory is exclusive and absolute, and it is susceptible of no limitation not imposed by the nation itself, that all exemptions to its full and absolute territorial jurisdiction must be traced up to its own consent, express or implied, that upon its consent to secede or to waive the exercise of a part of its territorial jurisdiction rests the exemption from that jurisdiction of foreign sovereigns or their armies entering its territory with its permission, and of their foreign ministers and public ships of war, and that the implied license under which private individuals of another nation enter the territory and mingle indiscriminately with its inhabitants for purposes of business or pleasure can never be construed to grant to them an exemption from the jurisdiction of the country in which they are found. The above is another way of expressing the operation of the Foreign Sovereign Immunities Act, 28 U.S. Code Chapter 97, in which 28 U.S. Code 1605 identifies the criteria by which foreign sovereigns such as the State of the Union and the inhabitants within them waive sovereignty immunity and become subjects to the jurisdiction of otherwise foreign law. Those mechanisms imply that when one purposefully avails themselves of commerce in a foreign jurisdiction, they are to be deemed resident aliens within that otherwise foreign jurisdiction, but only for the purpose of that specific transaction and not generally. Yeah, that part. Title 28, Part 4, Chapter 97, 1605, General exemptions to the jurisdictional immunity of a foreign state. A foreign state shall not be immune from the jurisdiction of the courts of the United States or of the states in any case in which the action is based upon a commercial activity carried on in the United States by the foreign state, or upon an act performed in the United States in connection with the commercial activity of the foreign state elsewhere, or upon an act outside the territory of the United States in connection with the commercial activity of the foreign state elsewhere, and that act causes a direct effect in the United States. The key is the phrase purposeful ailment. If you did not consent to do business in the forum and instead had your money stolen by an ignorant payroll clerk or financial institution and sent to the corrupt United States, then that government, one, becomes the custodian over stolen money, two, becomes a bailee and transferee in temporary possession of property rightfully belonging to the party who was the subject of unlawful withholding and or reporting. 3. Is required to return the funds even if no law or even the franchise agreement itself authorizes the return of funds. Hence, a statutory tax return available only to statutory franchisees called taxpayers need not be filled out, and a non-statutory claim should suffice. A claim against the United States is a right to demand money from the United States. Such claims are sometimes spoken of as gratuitous in that they cannot be enforced by suit without statutory consent. The general rule of a non-liability of the United States does not mean that a citizen cannot be protected against the wrongful government acts that affect the citizen or his or her property. If, for example, money or property of an innocent person goes into the Fed Treasury by fraud, to which a government agent was a party, the United States cannot lawfully hold the money or property against the claim of the injured party. American Jurisprudence, 2nd edition, 45. When the government has illegally received money which is the property of an innocent citizen, and when this money has gone into the Treasury of the United States, there arises an implied contract on the part of the government to make restitution to the rightful owner under the Tucker Act, and this court has jurisdiction to entertain the suit. One who gains a thing by fraud, accident, mistake, undue influence, the violation of a trust, or other wrongful act is, unless he or she has some other and better right thereto, an involuntary trustee of the thing gained for the benefit of the person who would otherwise have had it. The United States, we have held, cannot, as against the claim of an innocent party, hold his money, which has gone into the Treasury by means of the fraud of its agent, while here the money was taken through mistake. Without element of fraud, the unjust retention is immoral and amounts in law to a fraud of the taxpayer's rights. What was said in the state bank case applies with equal force to this situation. An action will lie whenever the defendant has received money which is the property of the plaintiff, and which the defendant is obligated by natural justice and equity to refund. The form of the indebtedness or the mode in which it was incurred is immemorial. 4. May be sued in state court under a replevin action without invoking the franchise contract, your all caps letter name, because the party whose funds were stolen did not consent to be a franchisee and therefore never purposely availed themselves of the franchise or the commercial consequences of the franchise, your all caps letter name. Here is how the above process of recovering funds unlawfully taken against a non-resident party as described in the FSIA. Title 28, Part 4, Chapter 97, 1605, General Exemptions to the Judicial Immunity of a Foreign State. A foreign state shall not be immune from the jurisdiction of courts of the United States or of the states in any case in which rights and property taken in violation of international law or in issue, and that property or any property exchanged for such property is present in the United States in connection with a commercial activity carried on in the United States by the foreign state, or that property or any property exchanged for such property is owned or operated by an agency or instrumentality of the foreign state, and that agency or instrumentality is engaged in a commercial activity in the United States. That's crazy, man. Below is the sequence of events that create implied consent to the franchise, creates the statutory civil person, individual and resident, transports your identity to Fed territory, places it within the jurisdiction of a Fed franchise court, and creates what the courts call a Fed question to be heard only in a Fed court. In other words, the franchise agreement dictates choice of law that kidnaps your identity and moves it outside the protection of the state law and the Constitution and onto Fed territory. 1. Through deceit, fraud, and adhesion contracts within financial account applications and employment withholding paperwork. You are illegally coerced to apply to receive and become a custodian of government property. The legal definition of public office confirms that a public officer is in fact someone who manages public property. The property you receive is the social number card, the social number, and the taxpayer identification number. These numbers act as the equivalent of a de facto license numbers giving permission from the state for you to engage in the functions of a public office. The IEDS regulations at 26 CFR 301-6109-1 confirm that the use of the number is only mandatory in the case of those engaging in a trade or a business, which is defined in 26 U.S. Code 7701A 26 as the functions of a public office. Public office, the right, authority, and duty created and conferred by law by which for a given period, either fixed by law or enduring, or the pleasure of the creating power, an individual is invested with some portion of the sovereign functions of government for the benefit of the public. An agency for the state, the duties of which involve in their performance the exercise of some portion of the sovereign power, either great or small, where by virtue of law a person is clothed not as an incidental or transient authority, but for such time as it denotes duration and continuance with independent power to control the property of the public, or with public functions to be exercised in the supposed interest of the people, the service to be compensated by a stated yearly salary, and the occupant having a designation or title. The position so created is a public office. Whew. Wow. All right. 7 minutes. The use of said public property and de facto license and the number that goes with it constitutes a prima facie implied consent to engage in the franchise and accept all of its terms and conditions. Hence, your implied consent makes you into a presumed de facto public officer and transferee managing Fed property. Any commercial transaction you consent the de facto license number to consent to donate the fruits of the transaction to a public purpose in order to receive the benefit of government franchise. 3. Implied consent to the franchise contract creates agency on the part of the applicant. All contracts create agency, which, as a bare minimum, consists of delivering the consideration called for under the contract. The courts and the government illegally treat this agency as a public office as described in 26 U.S. Code 701A26. They do this unlawfully because nowhere in the IEDS Code are the creation of any public offices in the government authorized by the use of any tax form or any identifying number. The consideration they define by fiat as consisting of obedience to the laws and dictates of a legislative foreign jurisdiction. 4. Third parties are lied to by the IRS into producing false legal evidence that connects private people with a public office. For instance, IRS falsely tells everyone that every payment in a legislatively foreign jurisdiction and outside their territory must be reported using information returns such as IRS Form W-2, 1042 S 1098 and a 1099. The reports must contain taxpayer identification numbers, employer identification numbers, and social numbers, all of which are only mandatory in the case of those lawfully occupying a public office in only the District of Columbia and no elsewhere pursuant to 4 U.S. Code 72. This has the practical effect of electing third parties into public office without their consent, and in most cases also without even their knowledge, since they weren't aware how the scam works. They never bothered to rebut the false evidence and hence are compelled to act as a de facto public officer in criminal violation of 18 U.S. Code 912 and to satisfy all the obligations of the office without any real compensation. That's wild as shit. 5. The public office, the trade or business that is fraudulently created using your implied consent means that you are acting in a representative capacity on behalf of a Fed corporation, which in this case is the national government, are a statutory U.S. citizen because the United States Fed corporation you represent is a statutory but not constitutional citizen. A corporation is a citizen resident or inhabitant of the state or country by or under the laws of which it was created and of that state or country only. 19 Corpus Juris Sectum Corporations 886. 6. Fed Rule of Civil Procedure 17b is used to transport your identity to the District of Columbia because that is where the U.S. incorporation is domiciled and located. Who is the real party in interest for those acting in a representative capacity? Yeah, please. 4. Parties. Rule 17. Parties, plaintiff, and defendant capacity. Capacity to sue or be sued. Capacity to sue or be sued is determined as follows. 1. For an individual who is not acting in a representative capacity by the law of the individual's domicile. Yo, that is wild. That's wild. That's wild. They make you not be able to sue them. Yeah, I got you choking on that shit. 2. For a corporation, the United States in this case, or its officers on official duty representing the corporation by the law under which it was organized, laws of the District of Columbia. And 3. For all other parties by the law of the state where the court is located except that a partnership or other unincorporated association with no such capacity under that state's law may sue or be sued in its common name to enforce a substantive right existing under the United States Constitution or laws, and B. 28 U.S. Code 754 and 959A govern the capacity of a receiver appointed by a United States court to sue or be sued in the United States court. 7. The franchise contract is then used to transport your identity against your will to the domicile of the U.S. Incorporated in the District of Columbia. For example, 26 U.S. Code 7701A39 and 26 U.S. Code 7408D are used to transport your identity to the District of Columbia under the IR Code. The citizen or resident they are talking about is the public office and not the human being and officer filling the office. Title 26, Subtitle F, Chapter 79, 7701. Yeah, that's why this country is going through judgment. You hear me? Title 26. All right, 7701 definitions. When used in this title, were not otherwise distinctively expressed or manifestly incompatible with the intent thereof. Persons residing outside United States. Was that United States? If any citizen or resident of the United States does not reside in or is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provision of this title relating to a jurisdiction of courts or B enforcements of summons. Yo, they out here wilding like shit. Okay. Shit. Title 26, Subtitle F, Chapter 76, Subchapter A, 7408. Actions to enjoin specified conduct related to tax shelters and reportable transactions. Yo. Citizens and residents outside the United States. If any citizen or resident of the United States does not reside in and does not have his principal place of business in any United States judicial district, such citizen or resident shall be treated for purposes of this section as residing in the District of Columbia. Okay, I gotta stop there. All right, I'm gonna redo it again on the next chapter later.